Welcome to the Agent Legal Lounge, the ultimate interactive weekly webinar that answers your burning real estate practice, contract, and legal questions. Hosted by distinguished attorney John George, co-chair of the Texas Real Estate Commission Broker Lawyer Committee, CEO and General Counsel of Special Provisions, and managing member of George PLLC. Tune in each week for an exciting, laid-back, and incredibly informative hour as John explores the Texas real estate profession, tackles hot topics requested by brokers and agents, and even takes your questions live. Get ready to dive in. The Agent Legal Lounge starts right now.
All right, good morning. Good morning, everybody. Good morning, Ed. Good to have everybody here today. Doing real good. So really excited to see how many people we have online here. What I want to do today is try a new format. You know, we've started this is our third episode. And what I really wanted to start this with and continue is an open discussion. And I like to geek out on these contracts and real estate issues. And that's really what I would like to try to create today. So Ed's going to be here to kick me in the butt when I start being too much of an attorney and talking too attorney-like. So bring me back down to earth if I'm going too far the other direction. And what I'd like to do, if you have any questions, let's start with the chat. Put them in the chat so everybody can see. And then if we need to unmute and have a discussion about the question, let's do that. And a few things up front. This is just general discussion. This isn't legal advice by any stretch. Hopefully it's some good general instruction. We'll go through contracts. We can go through practice questions on the compensation issue. I really wanted to make it what's important to you and what's on your mind. Another disclaimer is I'm speaking on behalf of myself. I'm not speaking on behalf of TREC or Texas Realtors or any particular group or company. This is me speaking individually, so I'm not speaking on behalf of anybody. And we do have a varied audience today. So we have attorneys, we have agents, title companies. It's varied. So please keep that in mind when sharing and asking questions. Let's not use names or specific client names or numbers, or definitely not percentages. So just keep that in mind. But please share, please ask, because the more you ask, the better this is for everybody. And the one thing I want to jump in with, or I guess one of the qualifications, I have some pretty bad thunderstorms coming through my area right now in Houston. And so if I happen to hop off, Ed will pick up, and then I'll hop back on as soon as I can. So the first thing before we kick it off for questions, and go ahead and start putting them in. I have a load of questions that I can start rattling off, but I really wanted to come from you. What's on your mind? You have me now for an hour, so ask away. And I had a lot last week. Had a really good time at the Texas Realtors Conference, as I'm pulling up my screen to share here, and had a lot of questions up there. So that was really good. But the one thing I wanted to kick off today with is, we talked a lot in the past about the Texas Realtor forms in the new 2401, the 2402, 2406, all the registration, now called compensation agreements, or the addendum regarding brokerage fees. I wanted to start off today kicking off with the new TREC proposed change and look at this and maybe clarify an issue that you'll see in the red lines that are out there. I've noticed in some of the Facebook groups that I'm a part of that there's questions on one of the options, and I think there's a red line error out there I wanted to address now, and we'll see how it's formally addressed going forward. But so the first one is the big change for the compensation in the contracts, and this is in everything but the farm and ranch, is in paragraph 12 regarding seller contributions. So the first step we took as the Broker Lawyer Committee is we looked at a whole bunch of options, from doing nothing to adding a whole separate addendum, and we ended up with this language in paragraph 12. And it's the seller contribution towards buyer agent compensation. All right, this is out of the seller's pocket, straight to the buyer agent or buyer broker. All right, it doesn't flow through the listing broker. That's the cooperative compensation if it went that route. This is straight from the seller straight to the buyer's broker or buyer's agent. And historically, how this section was used was for just kind of general buyer expenses. And it had a blank that the seller contribute up to a certain amount for buyer's expenses. The problem we had where it didn't fit the actual compensation issue is if buyer's expenses was a defined term. And I'll go and skip forward to that. That's the second paragraph. You'll see it. Actually, let me move myself right up here. You'll see it right here. This defined term right there is what everything's listed below there. And what wasn't in there, you'll see now in a red line right there, is it didn't include brokerage fees. So if you had a seller contribution in the past, you couldn't use that to pay brokerage fees. So we've added in the new changes brokerage fees to that definition. So when we start going through the prior paragraph, it's now within what could be considered a seller contribution. So knowing that not every seller wants to pay for buyer agent compensation, we wanted to split it up to say we want to allow sellers to have the ability to contribute to expenses, just like they always have, but we don't want to necessarily tie it directly to buyer agent compensation because of that concern. Sellers won't want to do it. So we created a second subparagraph and are allowing sellers to contribute for all these other buyer expenses and then specifically for buyer agent compensation. And we, in the language here, try to make it as clear as we could. And I'll walk through that now. So I make another co-host here. So what we did, if you look in the blue, this blue lines here, we call red lines. So if you hear TREC, this is really good that TREC does is produce these contract changes with these red lines so you can see what's different, see what's coming out. And the first section you'll see is we are changing it to make it just a positive sentence. Sellers shall pay the following expenses, right? We just changed that, didn't change any substance. And then we break it down to sections. And what I'm going to do here is pull out each section so we're not caught up in this big old paragraph that we're trying to look at. And then we'll see what each section says and what it means. And so if we go to the first section, sellers shall pay the following expense. And this is subparagraph A of paragraph 12. So you have releases of existing liens, prepayment penalties, recording fees for there's a release of that existing deed of trust. It goes through all these things that the seller pays. And we added a sentence in there just to clarify that the brokerage fee seller has agreed to pay is something that's going to come out of the seller's pocket. Right? So this is just a general statement. It always was what the law was there, what the contract provided, but because we're adding this new concept in later provisions of buyer agent compensation, we wanted to add that to the seller expressly paid items. Then we get into the new stuff. This is the real new stuff. This is, again, underneath that big subheading that sellers shall pay the following expenses. And you'll notice right up here in that definition or that parenthetical, that makes it a defined term. Just like we went over just a minute ago, that big long list of things for buyer expenses, this is a defined term for seller expenses. So the new paragraph, subparagraph B says the following amount to be applied to brokerage fees that buyer has agreed to pay. And then it has a blank for a dollar amount or a blank for a percentage. And it says check one box only. Okay, so it seems simple, but I've seen a lot of comments out there that questions on, well, what does it mean that buyer has agreed to pay? Right? Why did we put that statement in there? What's the actual intent behind that? What's the legal impact of that? Well, that's put in there to say that this is something, and to look at the big national lawsuit that's out there, of having buyers having to agree to pay something, of not having with the NAR rules that are there that requires a buyer's agent to have an agreement with their buyer's agent to pay X amount, right? We have to have a specific amount now, and we have to put a cap on it. And so because realizing what the actual practice is, this is a provision to make sure and try to keep the actual practice aligned with the contract. And so we made the statement that buyer has agreed to pay these fees. And if so, a seller puts in, let's say, $10,000 in this amount or X amount, whatever amount it is, then if the buyers only agreed to pay up to, let's say, Y amount, which is less, well, they can only get the Y amount, the lesser amount, even though the sellers agreed to pay more. And that's in line with the practice and the rules that are governing the vast majority of agents out there now, right? So this is a provision that buyer has agreed to pay. And so it's an amount, and hopefully it's the same amount that's there, but there has to be an agreement out there to pay it on behalf of the buyer. If it's excess, if it's more, then that whatever amounts in the buyer's rep agreement or whatever amounts in whatever contractual relationships there, then that won't be provided. So if it's X and it's actually lower in Y, you're only going to be able to get Y out of there. But that's the intent behind the brokerage fees that buyer has agreed to pay. Now that gets into a whole separate discussion on, well, what if my buyer's willing to pay me more, right? Then you can amend your buyer's representation agreement at that point. But that makes you have that discussion with the buyer that they're offering excess here. And the buyer may say, I want to keep the excess. I don't want to give it to you, buyer's agent. And that's again, separate discussion, but that's the thrust of why that language is in there about the buyer has agreed to pay. The next section is one that I believe we're going to have a correction on. And there was I think in translation from the broker lawyer meeting to the actual red lines, I believe there was a mistake. Don't quote me on this yet because it's something I picked up actually preparing for today. And everybody works really hard. There's so much going on there. It's just, we're all human at the end of the day. So if it ends up being the mistake, it actually is a very simple provision. And if you go through our the BLC minutes that will come out later, I put in here at the lower section, if you look down below, the typed out amount that's, let's see if I move myself over here so I can make sure you see. This is what is intended to say. An amount not to exceed X dollar amount to be applied to other buyer expenses. All right, we wanted two separate options for the seller contribution. One to buyer agent compensation, and then one to everything else that was historically a buyer's expense. We didn't want to do away with the old procedure. We wanted to keep the old procedure. And we wanted to add a new one to contribute directly to buyer agent compensation. And so the language as it went to the red lines, you'll see right over here, it kept the buyer agent compensation concept in there. So it's duplicative of the section B. So I believe you'll see a clarification on that. It's just, I believe, a clerical error. But it's really a simple concept in this paragraph if we go back to look at it overall, right? So we have three subsections. The first one is the seller's paying what they always agreed to pay, right? And we added a simple statement in there to make sure that everybody understood that include the listing broker's fees that they agreed to pay already. The second one is contributing, that B section right here, is contributing to the buyer agent compensation. And then the third one's the seller contributing some amount to everything else that's a defined buyer's expense, just like we always have in the past. So that's the thrust behind the new language. I didn't want to take up too much time, going through and droning on what's actually in there, but I did want to provide that clarification, let you know that's likely going to be clarified going forward on that, and that it really was intended to be as simple as we could make it. And so, teed up, Ed, if you want to kick it off with any questions that you have or that you're seeing in the chat, and I have plenty on my side I can throw in as well.
Yeah, we did have a question that came in, maybe on the same lines of that. There was a post by a law professor saying that our firms may be sidestepping the NAR settlement. Can you elaborate on that?
So I think I haven't read that article. I've had a reference to it, so I believe I know what they're saying, that lawyers and brokers are trying to get cute with the language to get around the rules. Right. In essence, is what I take from it. And I don't think that's the case. And from my involvement in this, and again, this is all speaking on behalf of me personally, we're trying to be exact with the language. We're trying to draft it in a way to have, I'm a big proponent of freedom of contract. The parties should be able to make the contracts that they want. You can many times use contracts in a way that's not appropriate. That is trying to get around something, even if the language is innocent and drafted for good intentions and good purposes. So any one particular brokers, I'm not sure what contract they're using or what the language might be in there that would be commented on in that article. But I can tell you, if you go back and watch it's 11 hours of meetings. It's literally us sitting in a room, videotaped, going through every single issue and analyzing it from the lawsuit concerns to practical boots on the ground concerns to every which angle. And we all changed our mind about 12 different times. You'll see the intent that's behind this section. And I wasn't in the room for the other, whether it's Texas or other states, and when they're drafting their language, but I have a feeling it's the same way. And I can tell you for this, and it's all there for everybody to see, is we were trying the statutory directive on the broker lawyer committee for TREC is to try to simplify things, to protect the consumer, to make for efficient transactions. And we really circle back around to that when we're looking at all these changes. And this is our best earnest attempt to accomplish that. So I'm not sure exactly what the subsects are, but that's my general feeling when I hear that comment out there made of we're trying to sidestep or something. I think it's the frame that you bring to it a lot of the times. And but I'll be interested in reading that after this meeting.
Another question that came in: if these changes are made on Section 12, how will that change how we use 2406, which is the addenda regarding brokers' fees?
So I think that will largely make the 2406 informational only, because right now the 2406, which is the addendum, the exact addendum regarding brokers' fees. I know some people know this stuff by form number, some know it by names. But that's the form that's meant to be attached. It's a Texas Realtors form, meant to be attached as an addenda to the contract. It's meant to be part of the contract itself. And there's only one enforceable provision in there. The other ones are in terms of compensation amounts. And that is the compensation between the seller agreeing to pay some amount to the buyer agent compensation. And the other two ones in there that are involved the broker to broker compensation. You have a D1 and D2, and then D2 has two different subsections. The first one, D1 and D2, are informational only, right? The third one, which is just like a seller contribution that we have in the contract, will be a moot point at that when we have it in the contract to be able to do it there. And I believe Texas Realtors will revise this form at that point. And whether it stays in addenda or some other informational disclosure, it will be duplicative of what we have now in the contract. So I suspect it will be changed, and if it's kept, it largely makes it informational, except for the new sections they added, the intermediary fees, is something that will need to be addressed. So whether it stays as part of this form or changes up, that's a whole nother issue that's outside of those two that are in there. But so I guess circling back, let me get out of my lawyer brain, talking through this. You'll notice I whiteboard in my head a lot. And this is what I love about these things, because we can figure this out together. If it doesn't make sense, re-ask it a different way. But right. So the 2406 section D2B, currently the original only enforceable one, now we have an intermediary, that will be duplicative of what's in the new contract changes for paragraph 12 of the TREC contract. Those accomplish effectively the same purpose.
Okay. Change the subject just a little bit, John, here. Can we talk a little bit about hosting open houses? So it looks like we could possibly have three scenarios, right? One, an agent is holding their own listing open. Two, another agent within the same firm is holding that home open. And then another possible scenario would be an agent from one company is holding an open house for another company. Could you speak directly on that?
Yes. And so in all three of those scenarios, the assumption is they're holding the open house, right? In that case, they're representing the seller. And this to me ties into agency and understanding agency. And as it flows into the compensation issues, is making sure you understand if you're holding open the open house, either you're part of the listing broker and your obviously your fiduciary duties as the listing broker flow to the seller. If you're within the same company, right? It may be your fellow agent's listing, and you're agreeing to hold it open. Well, it's the broker's the one that holds the listing, right? So you're still operating under the seller. Your fiduciary duties still go to the seller. I think the one that confuses people sometimes, if you're with another brokerage and you're agreeing to be a showing agent on a property or holding an open house, you're a sub-agent, but you're sub-agent for this seller at that point, right? So your agreement's not directly with the seller, your agreement's with the listing broker. And that makes you a sub-agent of the seller. You're not directly contractually obligated to the seller, but you still have all your fiduciary duties because you're working for the listing broker who does have that contractual relationship with the seller. And so in that case, we have to look at if you want to represent a buyer that walks in the door, right? The buyer walks in the door. I'm not part of the listing broker. I'm with ABC brokerage over here. Well, that if you want to represent them could create an intermediary relationship because you are a sub-agent. You are representing your fiduciary duties to the seller at that point. And so you would have to look at, who you're representing. Now you're not, I say intermediary, your fiduciary duties flow there. Let me step back. Intermediary is the wrong term because you're not with the listing broker and same broker's not representing two people. But you cannot flow through there to represent both the seller and the buyer in that regard. So you would effectively have to create some intermediary relationship at the end. So it effectively be the same thing, but you would need an agreement directly with the seller to do that. So let me, whiteboarding my head here, let me recircle back to restate all of that. If you're a sub-agent, you're with a different broker that's not the listing broker. Buyer comes in, you want to represent them on the purchase of that property. You are still obligated to the seller under fiduciary obligations. If you wanted to represent them in that same deal, you would have to have some agreement with the seller. You would have to establish an intermediary relationship to do it. Now, if that buyer goes to separate house, your agreement ends with that seller or listing broker to hold the open house. Then in other transactions, you could be representing the buyer, right? But you have to make sure your agreement's clear and where your silo is in your representation of that seller and where your silo is in your representation of that buyer. So you don't get into a de facto intermediary relationship that can get everybody in trouble.
All right. Thank you so much for that. And also, now that there's a requirement to have a buyer's representation agreement in place before we start working with buyers, touring, is there any requirement that the listing agent can do to either have the buyer agent show them that representation agreement, or is that representation agreement between the buyer and the buyer's agent?
Make sure I heard it correct. Can the seller require the buyer's agent to produce a copy of the buyer's rep?
Yes. Mm-hmm.
Yeah. No, they cannot. They can always ask for it, but there's no. One thing in all these agreements, there's no confidentiality clause, right? And baked into the standard contracts, the Texas Realtor forms or the Texas Real Estate Commission forms. There's not a confidentiality clause in there. But at the same time, you're representing your client and you have to take direction from your client. And so the seller may say, I want you, listing broker, to go ask for a copy of this. I want to make sure that they have it. On the buyer side, as buyer's agent, without talking to your client, you would risk breaching fiduciary duties if you just provided it, right? There may be a reason to do it, right? If you're getting into the middle of a deal and you want confidence and a good offer and you're not worried about it as a broker, make sure you talk to your broker, get with your broker first, and talk to your buyer, talk through here's all the concerns that can come up if we produce it. Do we want it out there? Or I think in most cases they won't want to produce it, but it's situational. And in that case, make sure it's your buyer's desire and your buyer's informed decision on whether to do it or not. Never just do it under your own as the agent. Somebody asks for it, here it is. Never do that without going through your buyer, making sure your buyer is fully informed and understands what you're doing and why you would like to do it, or actually it's their decision why they may or may want to do it or like to do it. So no, and we're going to get into a situation where now we have contributions up to a certain amount. Well, I want to make sure you're being honest and that you actually agree to pay it. You know, who's the enforcer of this? Who is it going to be? Title? Is it going to be TREC? Is it going to be Texas Realtors? And there's not a good answer to that. There's not a good. It's definitely not going to be TREC or Texas Realtors saying, here it is. You know, it's, you have to produce it, give it to us, and we'll check it. That's not going to happen. So it's going to be policing. It's going to be us a lot of self-policing to when we find out the bad actors that are not following the rules, that they're reported, that ethics complaints are made. You know, so this again, go back, is this is an NAR rule, right? And so if you're a member of NAR and you're Texas Realtors, then you're bound by it. And there's two separate complaint processes. You have Texas Realtors, a trade association, non-governmental entity, and you have TREC, which is the governmental body, and they each have their own processes, their own complaint processes. And if you're not providing or securing a buyer's rep under the NAR/TXR rules, that's under the Texas Realtors realm. Make a complaint. And under the ethics rules, they're requiring it. Under the NAR rules, it's required. And if you didn't provide it, then you can be subject to penalties. You can be subject to losing access to the resources that those entities provide. Because it's not a TREC rule, it's not a TREC requirement for that. I think any complaint that would be made on those grounds would be looking at fiduciary or not having the conversations or not meeting your duties under TREC rules. But those duties right now under TREC don't include having a buyer's rep. There's no absolute requirement to have the written agreement. I think it's absolutely advisable on every deal to have one, and it always should have been that way. But TREC does not have that requirement in place for you to sign up a buyer's rep on every deal. Now, if you want to collect a commission from a buyer, you have to have a written agreement, right? So if the buyer doesn't pay you at the end of the day, you cannot go collect the commission as a buyer, broker, buyer agent from a buyer without a written agreement. So it's especially now that we're getting more and more sellers that are not paying any cooperative compensation, not paying any contributions, it's going to be all that more important to have that written document there. And let me make a quick qualification that I think a lot of people are shocked when I say this is most understand that requirement, that written requirement between the buyer and the broker, or the seller and the broker, to be able to collect a commission. But between brokers, the agreement does not have to be in writing. You can enforce an oral broker to broker agreement in regards to the sharing of commissions. And you can see how that quickly can get scary. What did they exactly say was the commission amount? Oh, there was these texts out there that then established an agreement. Are you getting to a lot of the legal concepts that make these waters real murky? And that's why it's really, really important up front to get it established in writing. Whether it's with the client or whether it's with another broker, establish those rights up front so they're clear. So you don't get stuck in a situation of, well, they made an offer to me on the phone of X, and now they're trying to pay me Y, and it's different. So remember, broker to broker, it can be oral, but it definitely should be in writing to protect both sides and your parties too. Because if let me go one more tangent, and I'll shut up and go back. I feel myself being too lawyerly now. But you can have a situation where you, as a buyer's agent, you thought you had a firm agreement with the seller's agent that was oral, and then you tell your buyer that they're willing to pay cooperative compensation of this amount that you'll get a credit for, right? Remember, under the buyer's rep, they get a credit for the amount that you get from the listing broker or the seller. But at the end of the day, you didn't establish a clear broker to broker agreement, and that listing broker says, I'm not paying you. We never had something. Well, then you just put your buyer in a really bad position, right? They may have been counting on the financial side of having contribution to enter the contract amount that they did. It may completely change what they would have offered up front. And then you're looking at not only potential issues with Texas Realtors, but then that goes to violating fiduciary duties and an absolute TREC issue, right? And that's not just, penalties and losing resources. That's penalties and having issues on your actual license. So make sure you establish these agreements up front. Don't ever rely on the oral agreement between parties. You want to make it clear not only for your own benefit as a broker and agent, but for the benefit of your buyer or seller at the end of the day.
That's really great advice.
Did I talk too much on that one? Is that?
Yeah, that's very, very good advice on that. But while we're on that buyer representation agreement, if we're using the short form, and that's 1507, and we choose broker obligation under showing services, can you clear up some confusion on that? Even though we are doing showing services, we still have a fiduciary duty, and we are working with that buyer as a client, correct?
Absolutely. Once you have a relationship as a client, and this is one thing I heard at the recent conference, that it's really good to keep in mind, client versus customer, right? And if it's a client, you're signing up a buyer's rep, right? No matter how limited it is, they're your client, and the fiduciary duties under TREC rules apply. And one easy way to remember this is there's a few things you cannot limit, and they're listed for you in very simple terms in the IABS. This is not only a good guide for our clients, but it's good for us to read to fully understand. And so one of the top sections there, and I have the IABS here, it states a broker's minimum duties required by law. It's the second big section in the IABS. These are things, no matter how much you limit it. And the situation you presented in the 1507, we're only showing properties. They're still your client, and you still owe them fiduciary duties and the duties under the TREC rules. And so beyond showing, if you go to the IBS and you pull that out, highlight this, and make sure you remember this, is you have to still convey, no matter what, all material information about the property. Right? So you can't stick your head in the sand. They ask you, well, does it have a foundation issue? And you know about a foundation issue, you have to disclose it. You can't say, I just wanted to show you the property, or agree to show you the property. I'm not going to tell you all this information I found out that's material about it. You can't do that. You have to convey that information. And then you have to present any offers that are received. Right? This historically, in the context you're saying of, I'm only showing houses, normally in a typical situation, or in a lot of cases, the seller's not making the offer, right? The first offer, by and large, comes from the buyer. But it doesn't have to be that way. And there's many cases that it's not, where the seller, for whatever reason, and we're going to see a lot more of this with unrepresented buyers, the sellers may be effectively making the first offer, drafting the offer and sending it over. If that happens and you're under a showing only agreement, you receive that, the other agent sends it to you, the listing agent or the seller directly sends it to you, you have to convey that to your buyer. Even under a showing only, you have to convey any offer received to your buyer. So no matter how much you limit it, disclose material information, disclose any offers received. Beyond that, take this as a business decision. Look at your brokerage, and I always say, what do you need to keep the lights on? Right? Look at this on how much service am I providing, and what am I charging for that service? And it was a great thing that as part of this discussion, as much as the confusion, as much as all the worry and about the industry as a whole, this is a good impact to look at your own business structure and how you actually help buyers. Right? So what if I can't afford to go show 50 houses to a buyer and keep the lights on? I have to structure my business and my offering a different way. Right? And I have to charge for it. If we want to look at this much, and I know I need to have this much revenue, well, here, buyer, this is why I'm charging this amount for the showing part of it. And okay, if you don't want the showing, somebody else is doing the showing, you use Show Me or some other, app that, does the showings, how much can I charge for the other parts of the process? And how much can I limit it that I do? The contract drafting, the negotiating, the closing, all these different aspects of the deal, you have to look at on, is it the whole picture like we, in the past looked to a lot of saying, here's an amount, we're doing everything for you? Or are we breaking it down? Are we saying, here's what we're doing and here's what we're charging for it on a smaller level? Keeping in mind, you can never do away with the, conveying material information or conveying any offer received. So I think it's a great opportunity to look at those things and really rethink your business and how you help clients, and then also help clients, because buyers sometimes can't afford the whole plethora of expenses that it does that we would need to charge as buyer's agents to keep the lights on, right? And so I think this will smooth out over time as both buyers get more used to it, as brokers figure out their business models and what they charge as their own independent businesses. I think it will level out to a reasonable place. It's just scary right now on taking these steps and these big changes that, we haven't had this big of a sea change in a long time. It's happened in the past, but this is the first time we've had this in quite a while. So I hope I answered the question. I know, again, got stuck on a bunny trail there, but let me know if I can circle back to anything on that.
Yeah. Looking pretty good in the chat. Do you want to go down any compensation scenarios that you have?
Yeah, so let me get out a couple on the notes here. And again, everybody feel free to jump in. This is your opportunity to get questions asked. And I geek out on this stuff and I could do it all day. So if I didn't have to keep my lights on, I would be on this Zoom call for 8 hours a day going through all this. I just love it, and it's a big thing. So here's the what are my thoughts? This question that came up, and thank Kirsten. I know she's been real helpful with. She did a great panel presentation up at the conference. She's helped out with these agent legal lounges before. This one came through her. What are your thoughts about a seller who wants to require a buyer to have representation? All right, so this is a seller saying, wait a minute, I don't want this person on the other side coming into this transaction unrepresented. This is scary. I don't want, they may not know what to do. They may not know the rights, and they may fumble through this and ultimately not close, I think is the thrust behind that. And that's a legitimate concern as a seller. And I look at this first, the TFD issue on the legal side. Unfortunately, there's a lot of lawyers, a lot of generalists out there that handle real estate property issues because of the nature of residential real estate law. I mean, there's relatively, look at other areas of law, to the amounts that buyers or sellers are willing to pay, or brokers are willing to pay, versus the amount that they can make elsewhere. That it doesn't entice a lot of people to become specialists. So you got a lot of journalists out there that know a lot about little in the contract, but the practical day-to-day and application of the contracts is difficult. And so when you're looking at it from kind of that lawyer perspective, when they sometimes have a hard time understanding these contracts, that agents practically know the application a lot of times better than the actual lawyers, and it's no knock against lawyers, it's just you have to spend a lot of time to understand how these actually fit in the practice. If you're not in day-to-day practice, it's hard to do that. So put that in the sense of a buyer, right? This is another thing I commonly say, you probably heard me say before, is remember your first deal as an agent. How much sleep did you lose before the closing? How many times did you wonder how to schedule that inspection? How to do all these practical things? Do I get the appraisal? Is that the lender? Do I call the inspector myself? Does the seller schedule that? All these basic concepts that over time we've learned. Some of it we learned in real estate school. Some of it we learned in practice. Buyers coming in without even the real estate school education, without having to pass the test to get their license. By and large, they have no clue about this process. They can be sophisticated, in whatever field they're in. They can be businessmen, they can be doctors, engineers. But in real estate, as smart as you are, understanding the actual logistics, the boots on the ground, the understanding the contracts is something different. So it's a legitimate concern of sellers. And the question was, can you require the buyer to have it? And there's several implications that come to mind on that. That one, we have to be careful on some of the laws, like fair housing laws, in that if we have any requirements like this, we're thinking about that we're doing it in terms of a seller, or entertaining as a listing broker, and talking with them, that we're making sure it's tied to the specific thing. We're looking at this holistically, that one offer may be better than the other because they're represented by a buyer's agent, because of the risk going forward with an unrepresented buyer. That, I think, is a legitimate concern and a legitimate request. To the extent that it's tying in, I'm making that request, but I'm really don't want to show it to this class of protected people, right? That we shouldn't be doing, regardless in any scenario. You would want to make sure that while you're doing in making a requirement to be represented or taking an offer over another is tied to that actual issue. Make sure it's down and understood and doesn't bleed into because of their family status, because of their race, because of their gender, because of their age. These other things that could lead to implications of other laws. And so I think there's legitimate concern. I think there could be legitimate, I would look at it on case by case deal too, not just a requirement. I don't want to look at anybody that doesn't, come in and represent it. You could have a very kind, nice, I could pop up and say, hey, I want to buy your house. And if being a real estate attorney, being in the field and I have my inactive sales agent license too. I got that back in the day when I was a lawyer. So I say us an agent, I'm an agent as well, inactive. If I pop up, if you had that policy of saying I'm not going to take any offers from somebody that's not represented, well, I have my license, right? And it would be disclosed in the contract. Well, let's say it wasn't a TREC contract, right? You've already automatically cut off what otherwise would be a good deal. And that could be, if you didn't have that conversation on the list side with your seller up front to say, here's some things that could happen. Here's why we may just want to still get them, but consider each one on a one-by-one basis and give scenarios like that or other similar ones, then you could be shooting your seller in the foot. But circling back, I think it's a legitimate concern. You can make some legitimate parameters around the acceptance of offers, but in the bigger picture, I think it's not a good idea because of potentially cutting off what otherwise would be good offers. And other reasons too, but that's a big one.
We did have a couple more questions pop up. If we want to switch over to the listing agreement 1101 in section 5, broker compensation. Since our last revision, John, we added 5A3, where seller authorizes broker to publicly disclose compensation for other brokers as specified in 5A. Question coming in the chat is this a must disclose if we are using this section on the listing agreement?
So this is it's an authorization to publicly disclose, right? An authorization is just allowing us to do it. It's not an absolute requirement to do it. Now, you want to have that conversation up front with the seller, and this is them authorizing you, and it's really protecting both sides. It's protecting both sides from a later dispute that if it is used, you didn't tell me I couldn't use it, right? In fact, you told me I could in this agreement. I would have the conversation of how you intend to use it up front, right? Since it is being authorized in here, we want to make sure that we're giving full information to our sellers. And so you would want to say, here's how I intend to use this compensation to the other broker. And there's lots of different ways to do that now, right? Before it was the MLS, and that's gone. So it could be on the broker's website within the confines if you're a member of NAR to how you do it. Or if you're not, it could be on the website, or it could be in other avenues. So you want to make sure that they're comfortable with the ultimate method that you and your broker are using to disclose that information. And again, I want to tie this back. It's circular theme of here. However you disclose it and say it, make sure it's clear. The MLS, whether you realize it or not, actually has a contractual language for the broker-to-broker contract. And when you signed up for MLS, it had that language in there. Here's how you earn it as a buyer's agent. Here's how I'm offering it as a listing broker. Now that that's gone, we're seeing a lot of just sign writers at the top that say some amount of buyer agent compensation. Well, what's the legal language behind that? What's the terms of that offer? How do I accept it? How do I think there's general understanding of the industry, and I don't want to say handshake deals, but it's a understanding that, okay, if I bring a buyer, then you're going to pay me at the end of the day. But will that stand up if it's challenged? If there's some little fork in the road that is an argument that no, you're not entitled to it because of XYZ circumstance? Be careful. Look at these issues on how you're offering it. How can the sign writers scare me because there's nothing more than a couple words, right? The websites, some are developing websites that have these MLS-like terms behind it on how you can earn it, or in the advertisements having more language out there. But brokers, please look at that issue and don't just assume with an ambiguous offer on what the actual acceptance is, because that MLS contractual arrangement's gone. So now you're forming another contract with the broker directly, not through the MLS or the association. And even if you use the association contract, if you use the 2402, right? Tony, you have to keep circling back to make sure I'm using 2401 or 2, right? The compensation agreement between brokers, right? That's an association form, but it's a contract, an independent contract between brokers. You're not required to use that form. You can have your own forms, or you can, within the confines of the other forms you have, modify them. That's your own contract. It's not like a TREC contract where you can't modify it on behalf of the client. You can't strike out things. You can't add to TREC contracts on behalf of the client unless you have a law license. But the brokers, this is their contract. They can draft their own contracts for broker to broker compensation. And it's to me very, very important to look at that issue and get out in front of it to make sure you don't get caught up later in a dispute over whether the commission has to be paid or not. Because ultimately that's going to harm the buyer and the seller. And especially the buyers counting on getting part of that cooperative compensation in determining what amount to make in the offer. You'll see a theme in that today. That's a big thing. We're ultimately need to protect the buyers and our clients, buyers, sellers, and our clients by having clear agreements up front and understanding this up front so they're not ultimately harmed.
So to follow up on that, if we're using 5A, right, we should have that 2402 in place before the offer comes in. So using up to in 5A2 would not be appropriate, correct? We don't want to put any up to. We don't want to be negotiating that point when offers come in. Would it be better to utilize 5B and allow that to be negotiated on the contract if that's the strategy the seller wants to go?
To start off, it's a seller-driven decision, right? We along the lines with our business practices and what we're willing to market the property under our terms, right? This is on both sides. You look at the seller-driven. What are their desires? We're establishing the bounds of our relationship, bounds of our fiduciary, bounds of what our understanding is up front. And so it's driven, I guess, driven by that. And I think that should be a large focus, that they understand these provisions and how they work. But then looking at it from the broker perspective, right? It has to fit in with the broker's model, and not every client's made for every broker, right? But in this particular case, I think it's more seller driven because it's the amount that they're willing to pay. And one clear way to do it, to get out of the cooperative compensation and the issues there, is just negotiate on a deal by deal basis with contributing straight from the seller to the buyer, right? That cuts out a lot of the middleman, cuts out the listing broker. And one change that I really like that Texas Realtors made to their form was saying, if you charge X amount and you agree to pay Y amount as a incentive for buyer agent compensation, but they end up not taking it, they're not represented, they don't have an agreement to take up that full amount, you don't get to keep everything. You don't get to keep that big number. The seller gets a credit off the amount they owe because you didn't provide it to the other side. It's not that you get like in the old agreements, you get to keep everything, whether they take it or not. I think that's a great, fair change. That's the reality of the situation. And it allows that to be then negotiated on a deal by deal basis. It gives the seller the ability to then make offers independently, right? If somebody wants a contribution that's not represented, well, I guess it would be represented in that case. If they want, some amount of contract by contract, allows them to do that without having to worry about getting stuck for the big number before, not cut down by the amount that's being offered to the other side. So I think it's a great practical change, a great change for sellers to more realistically understand the contract and to get the benefit or the expectation at the end of the day of the amounts, because that was intended to be used to incentivize and pay somebody for representation on the other side. Which, one last point, we talked about why that's important, why that may be important to a seller, right? To help a deal go through smoothly. And I think everybody should have representation in all these deals. Biggest purchase of their life, confusing contracts, attorneys cost a whole lot. I can afford to hire myself on a lot of the transactions if I'm going to buy a lot or something like that to get attorney in. That's why agents are so important, and we need buyer representation. We need somebody on their side to help negotiate and explain these things.
Totally agree. However, if an unrepresented buyer does submit an offer to a listing agent, what type of duties are they obligated to do for that specific unrepresented buyer?
So we're not representing them, right? If they're unrepresented and we're the listing broker, unless we establish an intermediary relationship, all of our duties go to the other side or to the seller. The one thing that's part of fiduciary duties, that's a qualification here, is you have to treat everybody fairly and impartially, right? That's everybody in transaction. Your fiduciary duties, no matter who you represent, what side, everybody has to be treated fairly and impartially. So with that in mind, you don't have to draft a contract for them. You definitely don't want to provide any advice in terms of how much time should I put in this blank? How much should I put down for earnest money, right? That discussion should be had with your seller. And you go back to your seller and say, this unrepresented buyer is asking me these questions. I can't advise them on these. But here's the deal points. Here's who that buyer is. Here's why it may be something you want to consider effectively on our side drafting the contract. What terms do you want in there? Do you want us to draft the contract and make it from the sell side, which feels a little weird. I admit that feels weird doing it, but it's possible. Or do you want me to go tell them this is what you request to be put in that blank? And for seller protection later on, if the client, let's say it was a reasonable client up front, they had a life situation happen, they get stressed, and they forget all your conversations. They all of a sudden become the stereotypical crazy client that is not rational for whatever reason in life, woke up on the wrong side of the bed or a family situation. You want to make sure if you're telling that buyer, this is what my buyer said to put in this blank or they want in that blank, get that in writing from your seller first. You don't want to have to get into the situation with an irrational client that you may have had a bad breakup with that's now making a TREC complaint saying they were advising that buyer another side. They weren't looking after my interests. I never would have agreed to this amount of option or that amount of this many days. So it's really important to mitigate your liability up front, to mitigate that concern, to get all that confirmed in writing with the seller. And then you can feel more comfort that I'm doing my seller's wishes. We had that discussion. I'm telling the buyer, they don't want me to fill out the contract and make an offer, but they're authorizing me to tell the buyer this is what they want in those blanks. And if that buyer then turns around and says, well, what are my options? What can I put less? Can I put more? You can't advise them on that. You're not representing them unless you establish that intermediary. So, just be very careful on that. It's really the front end work that protects you at the end.
Mm-hmm.
And all too often, I think we as a profession rely upon, well, it won't happen to me. It's going to go through smooth. Heaven forbid you're thinking about the paycheck, right, and putting that first. But we can get too comfortable in these simple practices of confirming via email, confirming in writing. If a TREC complaint's made later, you have it right there. Otherwise, it's going to be a he said, she said. No, that's what she told me on the phone, or he told me on the phone to tell the buyer. Don't put yourself in that situation. It's too easy with today's technology to shoot an email, to shoot a text, to get a confirmation back that this is what you want me to convey. And then that could really save you later on if a TREC complaint is made or Texas Realtor's complaint is made, you have that documentation.
Okay. I think we have time for probably a couple more questions or a scenario, John, if you have it.
Sure. So let's see. Another one we have here, should the concern for brokerages that offer BAC up front on their websites, for example, are there potential liabilities for the broker? That goes back to the discussion on making sure your business to business, your broker to broker deals are clear because they impact our clients. And so, yes, I do have a concern about offering on the websites if it's just very vague. And I've seen a lot that, I've seen a few that have said, we're offering up to a certain amount, right? And they're thinking that we're going to offer up to the amount that the buyer's willing to pay or has agreed to pay their side, right? And so they're using this up to language, not understanding that's a vague offer, right? And that's would subject them to a lot of liability down the road if, from many different parties potentially suing. on that. So if you're doing anything on your website, make sure it's clear and really analyze that what legal language you need up front to avoid potential pitfalls. And then in generally, there's what I've heard being termed, and this isn't my term, but I've heard it being used as a 2-click rule, right? So off MLS, making sure that you don't go directly to a page that makes an offer. So if you have anything that from MLS takes you to your website, make sure that offer compensation is not right there on that first click. Make sure they have to go elsewhere on your page to get it. And not necessarily looking at the actual legal ramifications in terms of the NAR rules, but just practically speaking, that makes sense. And I see why. I believe that came out from the Texas Realtors. I don't want to quote who said it, but it makes sense of why you wouldn't want to run that risk of having it one click away under the Texas Realtor rules, or NAR rules, to prevent you from being put in that situation of having to defend it. And I think it definitely does risk violating the actual NAR settlement, or at least the spirit of it.
Okay, John. Hey, I do have a question here in the chat. Trying to ascertain whether, as a listing broker, taking on and going on to a listing presentation and talking to a potential client, would it be wrong to have a policy that says, we're not going to take your listings unless you offer buyer broker compensation?
Is it a violation to say that? And this kind of goes back to what we were talking about earlier about tying into other potential laws. I'm not aware of anything that would prevent that from being a policy standalone by itself, because it's a business decision at the end of the day. I'm a big believer in freedom of contract. We have protected classes for a reason. We have laws for a reason, that you can't discriminate on for family status, for gender, for race, for these things. This isn't a category of an unrepresented party, to my knowledge, that fits in any of those categories. But it's so easy to bleed over. That's where, if you want to have a policy like that, absolutely make sure it's very clear and very outlined, and with your own thing, so you don't get stuck in the situation of having to defend a fair housing complaint. And don't just dress it up to hide it, right? And I think this is an earnest question that's coming out a lot, and so I'm not reading any intent behind it, but I can see how the intent can go the other way and be argued in a case. So I think there's nothing that would absolutely prevent it, but I think it's at the end of the day, I think it's not a good decision for a client. And if to have that there, it's to me, I don't think a generally good idea is possible, and there may be reasons some particular broker will want to do it, but on a large scale, I think it likely would not be advisable, because every situation is different, every deal is different, and you should be analyzing it both as a broker and a client on the individual scale. Gotta love that lawyer answer there. It depends, and
yes,
without
right.
a firm answer, I shoot myself for saying that, but I think that's the reality of that, to my knowledge.
And if I could just make a note, if you can hear me, okay, I hope. I would just say too,
Yes,
and I kindly ask, why are the listing agents so worried about the buyer's agents getting paid? Just a thought. Don't need any discussion because it's time to wrap up. But I just wanted to place that out there for listing agents to think about.
That's a very, very good point. And I appreciate the reminder that it's 12, to respect everybody's time. But yeah, that's the fundamental things. Don't get lost in the weeds on a lot of this stuff. Look at the bigger picture, just like Kirsten turned us right back around to. I appreciate that. That's the practical stuff. Get me out of the lawyer brain. So each week, I like this format. I'd like to bring your questions, send us your questions in advance so we can address them and develop our future lounges, around that. I think conversation may be it for a while, but I'm doing this for you, and I'm doing it for myself because I love this stuff. I love talking about it. So thank you, Ed. Thank you, Kirsten, and we'll do it again next week. Take care.
Right.